My name is Ethan Walker. I'm 34 years old, and for most of my adult life, I've been the kind of person people describe as steady. Not brilliant, not dramatic, just steady. I work in international logistics consulting, quiet contracts, cross-border compliance, long hours in cities where no one knows my name. For the last 5 years, I've been based overseas, building a career that looks, from the outside, respectable but unremarkable. I don't post much. I don't argue loudly. I don't demand attention in rooms that weren't built for me. If you asked my extended family to describe me, they'd probably say I'm the practical one. The son who never caused trouble. The one who moved away and didn't ask for help. The one who could handle things on his own. And maybe that was the problem. This story isn't about sudden revenge or dramatic confrontations. It's not about shouting matches in courtrooms or explosive family dinners. It's about something quieter, and in many ways, more unsettling. I discovered that while I was working overseas, my own parents had declared me legally incapable of managing my affairs. On paper, I had been labeled mentally unfit. On paper, I was no longer trusted to control my inheritance, an inheritance left to me by my late grandfather, a man who built everything from nothing and who once told me, in a hospital room that smelled like antiseptic and old books, "You see things other people miss." According to documents filed back home, I was unstable, vulnerable, in need of protection. Those documents were supported by medical evaluations I had never seen. Medical evaluations I had never taken. They used forged medical records to strip me of legal authority over my own assets. And they did it while I was thousands of miles away, busy, silent, and unaware. What they didn't realize was that distance had never made me detached, and silence had never made me incapable. I didn't respond with anger. I didn't book a flight home in a fury. I didn't threaten or accuse. I did something else. I gathered records. Original ones. The kind that don't bend. This is the story of how I found out, what I chose not to say, and how I returned home, not to fight, but to correct the record. It's about perception. About what happens when the quiet one is mistaken for the weakest person in the room, and about the difference between being passive and being patient. I'm going to tell this honestly. No exaggeration, no dramatics. Just what happened, and how it changed who I am. Have you ever realized that the people who underestimate you might be the ones who never truly saw you at all? To my parents, I was the dependable one, not the charismatic one, not the rebellious one, not the fragile one, just dependable. Growing up in Seattle, I learned early that there are roles in every family, and once assigned, they rarely change. My older cousin was an ambitious entrepreneur. My younger sister was the emotional heart of the household. I was the bridge, the quiet translator between arguments, the one who smoothed things over, the one who understood documents, instructions, fine print. At family gatherings, if something needed to be explained, tax letters, insurance forms, mortgage adjustments, it somehow slid across the table toward me. Ethan will know. Ask Ethan. He's good with that stuff. It sounded like praise. It felt like utility. When my grandfather passed away, I was 29 and already working abroad. I flew back for the funeral, stood beside my parents in the front row, and said very little. My grandfather had been a measured man. He built a mid-sized commercial property portfolio from nothing but discipline and calculated risk. He valued structure, order, documentation. He and I used to sit together in silence more than we talked. After his passing, the estate discussions were handled internally, as my father phrased it. I was told not to worry. Everything was arranged. Trust structures were set up. Assets were being protected. Protected. That word came up often. At the time, I didn't question it. I was in Singapore managing a complex import compliance project. 12-hour days, multiple time zones. I trusted my parents to handle things responsibly. I assumed transparency would come naturally. It didn't. Whenever I asked for detailed updates, the answers were smooth but vague. It's complicated. You don't need to stress about it. We're making sure it's handled properly. Again, it sounded caring. It felt managed. I began to notice a subtle shift in tone during calls. My mother would ask if I was sleeping enough. My father would ask whether the overseas pressure was getting to me. At first, I interpreted it as parental concern, but the questions repeated, then intensified. Are you sure you're not overwhelmed? Working alone like that can affect people. You've always internalized things. Internalized, another word that started appearing more often. When I visited home one summer, I noticed something else. Documents were no longer casually shared in front of me. Conversations paused when I entered the room. My signature was no longer requested on certain trust-related correspondence. I was told some decisions required temporary consolidation. Temporary. I didn't argue. I didn't accuse. I simply observed. What my parents, and maybe everyone else, saw was a man who avoided confrontation. someone conflict-averse, someone easier to inform than to consult. They mistook emotional restraint for passivity. They mistook patience for incapacity. In truth, I was cataloging patterns. Dates, language shifts, email timestamps, legal phrasing. I wasn't angry. Not yet. But I was no longer unaware. Looking back, I realized something important. Invisibility doesn't always happen because people ignore you. Sometimes it happens because they think they've already defined you. And once someone believes they understand your limits, they stop checking whether they're wrong. To them, I was steady, predictable, non-threatening, the kind of son who would accept decisions made for his own good. What they never considered was that I was also my grandfather's grandson, and he never signed anything without reading every line. The first time something felt wrong, it wasn't dramatic. It was a missing attachment. I was in my apartment in Singapore, humid air pressing against the windows, city lights diffused through a layer of evening rain, when my father forwarded an email about a routine adjustment to one of the family trust accounts. Just informational, he wrote. There was a summary paragraph, formal tone, nothing alarming. But at the bottom, it referenced an attached addendum. See medical advisory note, page 3. There was no attachment, I replied casually. Looks like the addendum didn't come through. Can you resend? 3 days passed. Then 5. When he finally responded, the explanation was simple. Oh, that page isn't relevant to you. It was part of a broader compliance update. Nothing important. Nothing important. I remember staring at the screen longer than necessary, not because of what he said, but because of how quickly he minimized it. My father is precise with language. He doesn't dismiss things accidentally. I let it go publicly. Privately, I archived the email. That was the first small cut. It didn't bleed, it didn't sting, but it marked something. A few weeks later, during a late-night call, mourning for them, my mother's tone shifted again. We've been speaking with some advisors, she said gently, just to make sure everything is structured responsibly. Structured how? I asked. Oh, given your situation. My situation? Living abroad, stress, isolation. It's just different for you right now. Different. There was a pause long enough for me to hear my own breathing in the silence. I'm fine. Fine, I said calmly. Work's intense, but manageable. We know, she replied quickly. We just want to make sure you're protected. Protected. There it was again. The second small cut wasn't what they said. It was what they implied. That something about me required supervision. Later that month, I requested an official copy of the trust structure for my own financial planning. A reasonable request. I had a long-term property investment opportunity overseas and needed clarity. The document I received was incomplete. Sections were redacted, not blacked out, but summarized instead of reproduced. Language like authority currently consolidated under temporary guardianship review. Guardianship. I read that line 3 times. I didn't call immediately. I didn't react emotionally. Instead, I did what I always do when something feels structurally inconsistent. I cross-referenced. The phrasing didn't match standard estate law language in Washington state. Temporary guardianship review isn't casually inserted into adult beneficiary trusts without formal court involvement. That wasn't a parental adjustment. That was legal terminology. I scheduled a consultation with a compliance attorney in Singapore. Not about my parents, not yet. Just hypothetically. If an adult beneficiary were placed under guardianship without their knowledge, I asked, what documentation would exist? The attorney looked at me carefully. There would have to be a court filing, medical evaluation, formal declaration of incapacity. Incapacity. The word landed differently when spoken by someone neutral. I ended the meeting politely, thanked him, paid in full. Still no anger. Just alignment. The small cuts weren't random anymore. They formed a pattern. Missing attachments, medical references, protective language, consolidated authority, and beneath all of it, an assumption that I wouldn't question it. That distance meant detachment. That silence meant agreement. The first small cut wasn't when I discovered the guardianship language. It was when I realized they believed I wouldn't look closely. And that told me something far more important than any missing attachment ever could. What unsettled me most wasn't the legal terminology. It was how easily everything continued. No confrontation, no dramatic slip, just a steady stream of subtle repositioning. After the guardianship review phrasing appeared, conversations with my parents shifted into a softer, almost therapeutic tone. My mother began asking whether I had considered talking to someone about work stress. My father mentioned that extended international assignments can wear people down in ways they don't notice. They weren't accusing me of instability. They were implying vulnerability, and the implication repeated often enough that it began to sound normal. That's how it happens, not through one outrageous act, but through gentle repetition. When I questioned the guardianship phrasing directly, my father's response was calm. It's precautionary language, he said. Legal advisors suggested temporary consolidation to avoid complications while you're overseas. Consolidation of what? I asked. Decision-making authority. Just procedural. Procedural. The word was delivered like a sedative. I could have pressed harder. I could have demanded documents. But something in me hesitated. Not from fear, but from recognition. I was watching a narrative form around me. One where I was the overstretched son, the distant professional, the one too absorbed in foreign markets to manage domestic complexity. And because I had always been quiet, always self-contained, it was easy for them to project fragility onto my silence. The truth is, I did rationalize it, for a while. I told myself they were just being overly cautious. That maybe they misunderstood how international residency complicates estate structures. That perhaps an advisor overstepped and used language that sounded worse than it was. I chose calm over suspicion. But calm doesn't mean blind. I began reviewing my own communications history. I noticed how often my questions were redirected rather than answered. How requests for certified copies turned into summaries. How financial updates shifted from transparent spreadsheets to narrative explanations. Numbers replaced with reassurance. Details replaced with tone. And here's what disturbed me most. No one else in the family seemed concerned. At a cousin's wedding back home, I overheard an aunt say, "It's good your parents are helping you manage things. Must be hard being so far away." Helping me manage things. I smiled politely, nodded, didn't correct her, because correcting her would require exposing something I didn't fully understand yet. That's the quiet erosion, when mischaracterization spreads socially before you've had the chance to challenge it legally. Disrespect doesn't always look like an insult. Sometimes it looks like concern expressed on your behalf without your consent. Over time, I noticed how decisions were announced rather than discussed. We've adjusted the portfolio allocation. We've delayed disbursements for stability. We've structured it to protect you. Each sentence positioned me as the beneficiary of protection, not the owner of agency. And because I wasn't shouting, because I wasn't reacting emotionally, it became easier for them to believe the story they were building. That I needed supervision, that they were acting responsibly, that I would eventually thank them. The normalization of it was the most dangerous part. If they had been hostile, I would have responded immediately. If they had been cruel, I would have confronted them. But they were calm, measured, even affectionate, and that made the disrespect harder to name. The turning point wasn't outrage. It was clarity. I realized that if this narrative continued unchallenged, it would solidify, not just legally, but socially. And once a story about your incapacity becomes an official record, undoing it isn't emotional work. It's structural work. That was the moment I stopped rationalizing. Not because I was angry, but because I understood that silence, if left undefined, can be rewritten by someone else. There's a moment in every quiet conflict when you realize you're not being misunderstood. You're being positioned. It happened on an ordinary Tuesday. I was reviewing quarterly compliance reports when my phone buzzed with a message from my mother. "We had to finalize some paperwork today. It was time sensitive. You would have found it overwhelming with your schedule." Overwhelming. The word sat there, glowing on the screen. Not busy, not inconvenient, overwhelming. I didn't respond immediately. Instead, I replayed the last few months in my head. The softened tones, the protective phrasing, the gradual consolidation of authority, the subtle reframing of my independence as a strain. And then it became clear. They weren't reacting to something I had done. They were assigning me a role I had never agreed to play. The capable child had quietly become the vulnerable adult. Not because I failed, not because I asked for help, but because distance made the narrative easier to control. In their version of events, I was the son who needed safeguarding from the pressures of global work, the one who internalized too much, the one who might make impulsive financial decisions if left alone. The irony was almost mathematical. I built my career around compliance frameworks, risk assessment, and cross-border regulatory analysis. I advised corporations on documentation integrity, and yet, in my own family's structure, I was being treated as administratively fragile. Reliable, but not authoritative. Intelligent, but not decisive. Present, but not empowered. I realized something else, too. They weren't villains. They genuinely believed they were protecting the estate. Protecting stability. Protecting me. From a version of me they had quietly constructed. In their minds, consolidating control wasn't theft. It was stewardship. That's what made it more dangerous. Because when someone believes they're morally justified, they rarely see themselves as overstepping. I began to notice how conversations subtly reinforced this assigned role. My father once said, almost casually, "You've always preferred focusing on your work rather than dealing with domestic complexity." It sounded observational. It was categorization. The more I stayed calm, the more my restraint became evident. He's not pushing back, they must have thought. He knows we're right. But silence can mean many things: invisibility, shock, processing, or strategy. They had confused my temperament for incapacity, and I understood why. Growing up, I was the mediator, the one who de-escalated, the one who absorbed tension instead of amplifying it. That habit had served the family for years, until it was repurposed against me. I saw the full outline then. They needed me to be compliant, not rebellious, grateful, not questioning, protected, not empowered. And the role fit neatly because I had never demanded center stage. That was the assumption they leaned on, that I would continue being useful, continue being reasonable, continue being quiet. What they didn't recognize was that quiet doesn't eliminate awareness. It refines it. The day I understood the role they had assigned me wasn't the day I felt betrayed. It was the day I felt something else. Distance. Emotional, not geographical. Because once you see the script someone has written for you, you can no longer unknowingly perform it. And I had no intention of continuing the role. The shift didn't happen during an argument. It happened in an airport lounge. I was in Frankfurt, halfway between Singapore and a client site in Toronto. Delayed flight, neutral space, no family calls scheduled, no immediate decisions to make. Just time. I opened my laptop to review the quarterly investment summaries my father had sent earlier that week. Clean formatting, controlled language, reassuring tone. And then I saw it. A reference number in the footer that didn't match prior filings. It was subtle, one additional digit embedded in the case identifier. Most people wouldn't notice, but I track patterns for a living. Compliance filings are rarely creative with numbering systems. I cross-referenced it against Washington State Court indexing formats. The structure matched probate court filings, not internal trust adjustments. My heart rate didn't spike. There was no cinematic moment of realization, just a slow, precise tightening of understanding. If that reference number was legitimate, it meant a court had been involved. If a court had been involved, there had to be documentation. And if there was documentation, it existed independently of my parents' summaries. For the first time, the possibility moved from abstract suspicion to structural reality. I closed the laptop. I didn't call. I didn't text. I didn't confront. I sat there and watched planes move across wet pavement. There's a particular kind of clarity that comes when emotion doesn't override logic. It's almost unsettling. You expect anger. You expect hurt. Instead, I felt alignment. The pieces fit. The repeated medical references, the guardianship phrasing, the consolidation of authority, the softened concern about my overwhelm. This wasn't overprotectiveness. This was documentation. Filed documentation. And that meant one of two things. Either they had petitioned a court claiming I was incapable of managing my own affairs, or someone else had and they supported it. Both required medical evidence. Evidence I had never provided. I reached into my carry-on and pulled out the slim leather folder I always travel with. Inside were copies of my health clearances for international contracts, full cognitive evaluations required for high-security compliance work, psych assessments, physical exams, signed certifications from licensed physicians across multiple countries. All recent, all official, all contradict any claim of incapacity. I had never thought of them as leverage. They were just requirements for my job. But suddenly, they were something else. Proof of consistency, proof of competence, proof that whatever had been submitted in my absence could not align with reality. That was the shift. Not rage, not betrayal, but repositioning. Up until that moment, I had been reacting internally, trying to understand motives, rationalizing intentions. Now I began thinking structurally. If a guardianship had been filed, it required a petition. A petition required sworn statements. Sworn statements required signatures. Forgery isn't loud. It's quiet, administrative, ink on paper. And unlike emotional manipulation, paper leaves trails. I opened my laptop again, this time not to reread their summaries, but to draft a formal records request to the Washington State Probate Court. Neutral tone, no accusations, no family references. Just a beneficiary inquiring about case documentation under his own legal name. I didn't feel powerful. I felt calm. There's a difference. Power can be reactive. Calm, when informed, is deliberate. That was the day something shifted. Not in my parents. Not in the estate. In me. I stopped trying to interpret their behavior emotionally and started preparing to verify it legally. After I submitted the records request to the probate court, I didn't mention it to anyone. Not to my parents, not to my sister, not even to the attorney I had casually consulted weeks earlier. For the first time, my silence wasn't reflexive. It was strategic. There's a subtle shift when silence moves from habit to decision. It stops being passive and starts becoming selective. I wasn't withholding emotion. I was preserving leverage. In the weeks that followed, my parents continued speaking to me as if nothing significant was happening. How's Toronto? Are you eating properly? Don't let work exhaust you. Their tone remained gentle, concerned, protective. I listened carefully, not to what they were saying, but to what they weren't. There was no mention of court filings, no reference to medical assessments, no acknowledgement of any legal restructuring beyond vague adjustments, which meant one of two things. Either they believed I would never find out, or they believed that even if I did, I wouldn't challenge it. Both assumptions required them to underestimate me, and that realization didn't make me angry. It made me precise. I began tightening my own documentation habits. Every phone call was followed by a brief summary email, just confirming what we discussed. Per your note about consolidation, regarding the temporary guardianship language, neutral, professional, time-stamped. If they noticed the shift, they didn't comment on it. From their perspective, I was still calm, still cooperative, still the steady son abroad. But internally, something fundamental had changed. I stopped seeking reassurance. I stopped asking emotionally loaded questions like, why wasn't I told? Instead, I framed everything in structure. What statute governs that adjustment? Which filing date corresponds to that consolidation? Could you provide the certified copy rather than the summary? Each question was measured, non-accusatory, and increasingly uncomfortable. I could feel it in the pauses before my father answered, in the slight hesitation when my mother redirected the topic. They mistook my calm for retreat. In reality, I was mapping inconsistencies. Then the court envelope arrived. International mail, official seal. I waited until evening before opening it, not out of fear, but to ensure I had uninterrupted focus. Inside was a certified copy of a petition filed 8 months earlier. Petition for determination of incapacity and appointment of guardian. My name, my birth date, my social security number. Attached were 2 medical evaluations, both dated during periods when I was physically in Singapore. Signed by a physician whose name I did not recognize. The diagnosis cited executive dysfunction due to prolonged occupational stress and impaired financial judgment. I read every page slowly. There was no dramatic surge of emotion, just one clear realization. This wasn't overreach. This was fabrication. The medical license number listed on the document didn't align with Washington State's registry format. Even at a glance, it was structurally inconsistent. They had filed forged medical documentation. And because I was overseas, I had never been served in person. Notice had been sent to my last registered domestic address, my parents' home. Silence, in that moment, could have turned into rage. But rage clouds the sequence. I needed a sequence. I placed the documents back into the envelope, then into my leather folder, alongside my own certified medical clearances. 2 parallel realities, one fabricated, one verifiable. I didn't call them, not that night, because once you confront someone, you reveal what you know. And I wasn't ready to reveal anything yet. Silence had become something else entirely. Not weakness, not avoidance, but space. Space to build something irreversible. Preparation doesn't look dramatic from the outside. It looks like routine. That's why they never noticed. The week after receiving the court documents, my behavior didn't change in any visible way. I attended client meetings, submitted compliance reports, joined family video calls when schedules aligned. I smiled at appropriate moments. I listened. But underneath that surface, I was building structure. The first thing I did was verify the physician listed on the petition. Not emotionally, methodically. Washington State's Department of Health maintains a public license database. The number on the evaluation form didn't populate any results. I tried variations, adding digits, removing digits, checking archived records. Nothing. Then I searched the physician's name. There was one doctor with a similar name practicing in Oregon, but with a different middle initial, a different specialty, and a different license number. The document attached to the petition was either carelessly falsified or intentionally fabricated by someone who assumed no one would check. They assumed distance equals disengagement. They were wrong. Next, I requested the full court file, not just the petition. Every exhibit, every supporting affidavit, every service notice. The clerk responded within days. Additional certified copies were mailed. When they arrived, the pattern became clearer. An affidavit from my father stating concern over deteriorating decision-making capacity. A supporting statement from my mother referencing observable emotional volatility during overseas calls. Bank summaries implying erratic transfer behavior. Transfers that, in reality, were routine international tax payments, clearly labeled in my records. They had constructed a narrative, carefully worded, calmly presented, framed as a protective concern. There was no cartoon villainy, no exaggerated claims. Just subtle distortion. That's what made it dangerous. I printed my own financial statements for the same periods, highlighted timestamps, cross-referenced transfers, annotated exchange rates and tax codes. I downloaded archived video call logs showing consistent work schedules. I requested written confirmation from my employer verifying the cognitive and performance evaluations required for my role. Everything I gathered had one purpose: alignment. If their case relied on emotional implication, mine would rely on documented continuity. I also retained a probate litigation attorney in Seattle, quietly. Not a dramatic courtroom strategist, a meticulous specialist in guardianship reversals and fiduciary misconduct. Our first meeting was video-based. I don't want escalation, I told her. I want correction. She reviewed the documents slowly, asked precise questions, requested copies of my medical clearances. Were you ever evaluated by this physician? She asked. No. Did you authorize the release of any medical records to your parents? No. She nodded once. If these documents are forged, this isn't just a guardianship issue. It's fraud upon the court. The phrase landed heavier than anything before it. Fraud upon the court. But I didn't react emotionally. Instead, we mapped the sequence. Step 1. File a motion to vacate the guardianship determination based on improper service and falsified medical evidence. Step 2. Request a forensic review of submitted documentation. Step 3. Petition for temporary injunction preventing further asset consolidation pending review. No drama, just procedure. What they never noticed was how thoroughly I was built for this. Years of compliance training, years of understanding how systems protect themselves when presented with verified contradictions. I didn't need to shout. I needed to document. Meanwhile, conversations with my parents remained almost surreal in their normalcy. My mother mentioned the upcoming portfolio rebalancing. My father spoke about property maintenance costs. They still framed everything as responsible management. I listened. I didn't confront, because once legal filings begin, timing matters. There's a difference between arguing at a dinner table and submitting a motion stamped by a judge. One invites denial. The other demands a response. The most powerful part of preparation is that it happens quietly. They saw a son continuing his overseas contract. They did not see the certified mail accumulating in my Seattle attorney's office. They did not see the cross-referenced spreadsheets. They did not see the forensic document analyst reviewing signature pressure inconsistencies on the medical forms. They assumed the role they assigned me still fit. Overwhelmed, distant, passive. What they never noticed was that I wasn't preparing to attack. I was preparing to restore accuracy. And accuracy, when formally presented, doesn't require volume. It requires evidence. By the time the first motion was filed, they still believed I didn't know. That was the advantage of quiet. The leverage didn't feel powerful when I found it. It felt final. My attorney called on a Thursday morning, late evening for me in Toronto. Her tone was the same as always, steady, measured, unhurried. "The court has reviewed our preliminary motion," she said. "There's something you need to see." She forwarded a digital scan while we were still on the call. It was the original physician declaration attached to the incapacity petition. Not the photocopy I'd received by mail, but the scanned version filed electronically with the court. And in that version, something stood out immediately: the signature block. The physician's signature wasn't wet ink. It was digitally overlaid. The metadata embedded in the PDF, something most people never think to inspect, showed the document had been created on a home computer, not through a medical office system. The author field listed a generic user ID, not a hospital network, not a clinic server, a personal device. There are small details that change everything. This was one of them. My attorney continued calmly. "We've had a forensic document examiner review the file. The signature on the medical evaluation and the signature on the supporting affidavit from your father were produced by the same printer device. Identical toner distribution patterns. Same printer, different signatories." I leaned back in my chair and closed my eyes, not from overwhelm, but from clarity. This wasn't overzealous legal advice. It wasn't a miscommunication. The medical documents had been fabricated. At least one of my parents had either created them or knowingly submitted them. The private reveal wasn't that they had overreached. It was that they had crossed a line that cannot be reframed as protection. Fraud upon the court isn't emotional. It's a structural betrayal. And here's the part that surprised me most. I didn't feel rage. I felt grief. Not loud grief, not cinematic devastation, just a quiet recalibration of who they were in my mind. When you discover that someone was willing to sign a sworn statement declaring you mentally incapable while you were successfully managing international contracts, it shifts something foundational. But I still didn't call them, because now the equation had changed. Up until that moment, I was seeking restoration of control. Now, I was holding something far more consequential. If pursued fully, this could trigger a criminal investigation. Charges, public records, permanent consequences. My attorney asked me a question I will never forget. "How far do you want this to go? Not do you want justice? Not do you want revenge? How far?" There were options. We could focus solely on vacating the guardianship quietly, citing procedural errors, avoiding fraud allegations unless contested. Or we could file a formal motion alleging fraudulent medical documentation and request referral to the state bar and district attorney. One path corrected the record. The other exposed the truth publicly. I asked for 24 hours. That night, I sat alone in my hotel room with the leather folder open on the desk. On one side, their fabricated evaluation describes executive dysfunction. On the other, my certified cognitive clearance was signed by 3 independent physicians across 2 countries. The contrast was almost clinical. What struck me wasn't that I could win. It was what they had assumed I wouldn't check. That assumption told me more about their perception of me than any insult ever could. The private reveal wasn't a victory. There was clarity about leverage. And leverage, when held quietly, becomes choice. I realized something then. I didn't need to destroy them to correct this, but I also couldn't allow it to stand. The question wasn't whether I had power. The question was what kind of man I wanted to be when using it. I didn't sleep much that night. Not because I was anxious, but because clarity has a way of keeping you awake. There are moments in life when your options narrow into a clean, irreversible line. This was one of them. By morning, I had outlined 3 possible paths. The first was avoidance. Withdraw quietly. Relinquish claim to the inheritance. Let my parents maintain control. Continue building my career independently and treat the estate as something that is no longer concerned me. It would preserve the relationship on the surface, but it would also validate the record declaring me legally incapable. That was not just a financial loss. It was a permanent distortion of identity. The second path was correction without exposure. File to vacate the guardianship on procedural grounds, improper service, flawed medical verification, without explicitly alleging fraud unless they resisted. Quietly restore my legal capacity, regain control of the trust, and allow them an opportunity to retreat without public consequence. That option protected dignity, mine and theirs, but it also required trust that they would not escalate defensively. The third path was full exposure. Submit forensic evidence of falsified medical documentation, petition for sanctions, request a referral for criminal review. That route would not only restore my legal standing, it would permanently document what they attempted. It would also fracture the family in a way that could never be repaired. None of these options involved shouting. None involved humiliation. Every option involved the consequence. I asked myself a simple question. What outcome aligns with who I am, not who they assumed I was? I've never believed in destruction for the sake of symmetry. If someone harms you, becoming more harmful doesn't restore balance. It just multiplies damage. But silence, when harm is documented, becomes complicity. By midday, I called my attorney. We proceed with correction first, I said. We present the inconsistencies. We request vacatur. If they contest or deny, then we escalate. Measured. Irreversible but proportionate. The motion was filed that afternoon. Motion to vacate determination of incapacity due to fraudulent medical evidence and improper service. The wording was precise. It did not accuse recklessly. It cited discrepancies, metadata findings, licensing registry mismatches, printer analysis. It requested an expedited hearing. Once filed, the process no longer belonged to family conversation. It belonged to the court. That was the point of no return. Because once a motion like that enters the public record, it cannot be withdrawn quietly without acknowledgement. I didn't inform my parents. I didn't warn them. Not out of spite, but because due process requires neutrality. Service of motion would occur formally, through official channels. I imagined the moment they would receive the notice, the envelope, the seal, the language. For months, they had managed the narrative. Now, the narrative would require a response. I didn't feel triumphant. I felt steady. There's a difference between confrontation and correction. I wasn't confronting them emotionally. I was correcting their record structurally. And once structure shifts, outcomes follow. The decision point wasn't about revenge. It was about alignment. I would not live under a documented falsehood for the sake of comfort. Whatever came next would unfold in order, calmly, legally, irreversibly. After the motion was filed, everything became procedural, which is another way of saying quiet. There were no dramatic phone calls, no immediate emotional fallout. Legal systems move in measured steps, and during those first few days, the only visible evidence of change was a tracking number confirming service of process. My parents were formally notified 3 days later. I knew the exact window when the envelope would arrive at their house in Seattle. My attorney's office had arranged certified delivery with signature confirmation. I imagined my father signing for it, habitual, controlled, assuming it was routine correspondence. It wasn't, but I didn't call. Instead, I continued attending meetings in Toronto. I reviewed shipping compliance reports. I adjusted tariff projections for a client expanding into Southeast Asia. Externally, nothing shifted. Internally, everything had already shifted weeks earlier. Silence during this stage wasn't a strategy anymore. It was discipline. My attorney began preparing supplemental documentation, certified copies of my international medical clearances, employer attestations confirming cognitive performance standards, travel records proving I was overseas during the alleged in-person medical evaluations, a sworn declaration from me outlining timeline discrepancies without emotional language. The key was tone, not accusatory, not indignant, just factual, because courts respond to structure, not sentiment. 2 days after service confirmation, my phone rang. My mother. I let it ring once more than usual before answering. Her voice was steady, but thinner than before. "Ethan, we received something today." "I assumed you would," I replied. A pause. "You filed a motion against us?" "Not against you," I said evenly. "To correct a record." Silence. Then my father's voice joined on the speaker. "This is unnecessary," he said. "We did what we believed was appropriate, given your condition at the time." "My condition?" I asked calmly. "You were under enormous pressure," he continued. "We were advised that consolidation was responsible." "By which physician?" I asked. Another pause. "You're escalating this," he said. "No," I answered. "The paperwork did." There was no shouting, no accusations thrown back and forth, just tightening the space. They attempted reassurance first. "This can be withdrawn," my mother said softly. "We can discuss this privately." "It's already filed," I replied. "It requires judicial review." What they were feeling in that moment wasn't yet panic. It was a loss of narrative control. For months, they had framed decisions as protective adjustments. Now the framework had shifted from family discretion to court scrutiny. And scrutiny changes behavior. Over the next week, their attorney filed a response. They did not deny the guardianship petition. They did not deny the medical evaluations. But they argued that actions were taken in good faith based on perceived behavioral changes. Perceived. Not documented. Not verified. Perceived. The court scheduled an expedited hearing. I booked a flight home. Not urgently. Not dramatically. Just a return ticket to Seattle with a carry-on and my leather folder. Inside that folder were original, certified medical records, signed, stamped, authenticated by institutions that maintain digital audit trails. The contrast would not require an emotional argument. Only comparison. As the plane lifted off from Toronto, I felt something unexpected. Not anger, not anxiety, just clarity. They had moved in silence, believing I wouldn't notice. I had moved in silence, ensuring that when I did respond, it would not be negotiable. The hearing date was set for the following Tuesday. And for the first time since this began, distance would no longer protect anyone from consequence. I landed in Seattle on a gray Sunday afternoon. No one knew I was arriving except my attorney. I didn't go to my parents' house. I checked into a hotel downtown, neutral ground, the kind of place designed for quiet transitions, floor-to-ceiling windows, muted carpeting, no emotional history in the walls. Monday morning, my attorney filed one additional supplement with the court, certified originals of my international medical evaluations, along with notarized travel logs proving I was overseas on the dates I was allegedly examined in person by the physician listed in their petition. By midday, something subtle began to shift. My father's attorney requested a private conference call with the court clerk regarding procedural clarification. That's legal language for uncertainty. By late afternoon, a second filing appeared on the docket. Motion to amend prior petition due to administrative error. Administrative error. The phrase was careful, controlled, an attempt to reframe. But here's what happens when a case moves from narrative to documentation. Language tightens, excuses shrink, and timing matters. The judge denied their motion to amend pending the scheduled hearing. Once a motion to vacate citing fraudulent evidence is on record, procedural edits aren't casually granted. That evening, my mother called again. Her tone had changed, not defensive, unsteady. "Ethan," she said quietly, "we didn't expect this to become this." "Become what?" I asked. "A court matter." "It was filed in court 8 months ago," I replied evenly. Another silence. This one is heavier. For the first time, I could hear what they were experiencing. Not anger toward me, but the realization that structures they relied on were no longer under their control. Consequences rarely announce themselves loudly. They unfold. On Tuesday morning, before the hearing even began, the forensic examiner's preliminary report was submitted into the record. It confirmed that the medical evaluation document's metadata did not align with any registered medical software platform, and that the listed license number was invalid. Invalid. One word. No emotion. The courtroom was small. Probate hearings aren't theatrical. Fluorescent lighting, neutral walls, files stacked neatly on a clerk's desk. My parents sat 2 rows ahead of me. They did not turn around. When the case was called, my attorney presented documentation calmly. No raised voice, no accusations, just sequence, travel logs, medical clearances, license registry search results, metadata analysis. The judge asked a simple question to my parents' counsel. Can you authenticate the physician's evaluation? A pause. No, Your Honor, we are currently reviewing that issue. Reviewing. In the legal context, that word carries weight, because the inability to authenticate sworn medical evidence isn't oversight. It's exposure. The guardianship determination was temporarily suspended pending full evidentiary review. Suspended, which meant, immediately, authority over the trust assets reverted back to me. Not permanently, yet, but structurally. And that's when the consequences truly began. Not in shouting, not in collapse, but in recalibration. My father's attorney requested a recess to discuss potential resolution. Translation: they were calculating damage. When we stepped into the hallway, my father finally looked at me. There was no fury in his expression, just something I hadn't seen before. Uncertainty, not about me, about the outcome. For months, they had operated from a position of assumed authority. Now, authority was being examined under oath. Consequences don't always look like punishment. Sometimes they look like a loss of certainty. And in that hallway, beneath fluorescent lights, I realized something important. They were no longer managing the situation. They were responding to it. The hallway conversation lasted less than 10 minutes. My father spoke first. "This has gone further than it needed to," he said, voice controlled but thinner than I'd ever heard it. "It went to court before I knew it existed," I replied. He exhaled slowly, like a man recalculating a risk he had once considered manageable. "We were trying to stabilize things," he continued. "You were overseas, under pressure. The advisors recommended consolidation. The medical paperwork was expedited." Expedited. That was the closest he came to acknowledging fabrication. My mother stood beside him, arms folded, not defensively, but as if holding herself together. "We can withdraw everything," she said. "File corrections. Close this quietly." That word again. Quietly. But there's a fundamental misunderstanding about legal filings once they reach judicial review. You can amend a typo. You can't quietly retract a sworn statement declaring your son mentally incapable after forensic review has questioned its authenticity. "It's not mine to withdraw," I said evenly. "The court is reviewing it." My father's jaw tightened. "You don't need to pursue sanctions," he said carefully. "That would be unnecessary." There it was. The recognition. They understood the risk now. Fraud upon the court carries consequences beyond family disappointment. It can trigger bar referrals, investigations, permanent records that follow you professionally. For the first time, I saw something shift in them. Not control, not authority, vulnerability, but not the kind they assigned to me. The kind that appears when strategy fails. Back inside the courtroom, the judge addressed both parties directly. "This court takes medical incapacity determinations seriously," she said. "If documentation was improperly submitted, this is not a clerical matter." Not clerical, not administrative, not expedited. The judge ordered a full evidentiary review and requested verification directly from the physician's licensing board. A follow-up hearing was scheduled. In the meantime, the guardianship remained suspended, which meant one thing clearly: they had lost control. Not permanently, yet, but decisively. After the hearing adjourned, my mother approached me quietly while my father spoke with his attorney. "Ethan," she said, her voice almost unrecognizable now, "we thought you were overwhelmed. You don't tell us everything." I looked at her, not angrily, not coldly. "I don't tell you everything," I said calmly, "because I handle things." That was the part they never accepted. Handling things silently is not the same as being unable to handle them. She nodded once, but there was no reply. By the time I returned to my hotel that afternoon, their attorney had filed a notice of intent to withdraw the original medical exhibits pending verification. Pending verification. Too late. Once questioned formally, credibility doesn't reset with a filing. It fractures. Over the next week, the licensing board confirmed in writing that no such physician with that license number existed in Washington state. The record now contained official confirmation. Not my accusation. Official confirmation. At that point, even if I had wanted to minimize the outcome, I couldn't, because the issue no longer belonged to me. It belonged to the court, and courts don't prioritize family harmony. They prioritize the integrity of the process. That's when I understood something fully. There is a window in every conflict where quiet resolution is possible. They had that window months ago. They chose narrative control instead. Now the correction was public, not sensational, but documented. And once something is documented in a legal record, it doesn't disappear simply because regret arrives. It was too late to fix it quietly. Not because I pushed, because they assumed I wouldn't. The final evidentiary hearing was scheduled 3 weeks later. By then, the licensing board had submitted written confirmation that the physician listed on the incapacity evaluation did not exist in their registry. The forensic examiner's full report was also on record, detailing metadata inconsistencies and signature anomalies. There was no suspense left, only acknowledgement. The courtroom felt even smaller that day. My parents sat at the same table as before, but something about their posture had changed. Less upright, less certain. My father avoided scanning the room. My mother kept her hands folded in front of her, fingers intertwined tightly. When the case was called, the judge spoke plainly. The court has received confirmation that the medical evaluation supporting the prior determination of incapacity cannot be authenticated. The guardianship order is hereby vacated in full. Vacated in full. No qualifiers. No partial restoration. Full. Authority over my inheritance and financial decision-making reverted entirely to me, effective immediately. Then came the next part. The matter of how these documents were submitted will be referred for further review. Further review. The judge did not elaborate. She didn't need to. My father's attorney requested a moment to address the court. Your Honor, he began carefully, my clients acted under what they believed to be proper guidance. There was no malicious intent. Intent. It's a word people reach for when the outcome is no longer defensible. The judge responded evenly. Intent does not excuse submission of unverifiable medical evidence. That was it. No raised voices. No dramatic gavel strikes. Just a correction. After the hearing concluded, we all stepped into the hallway again. This time, there were no attorneys speaking first. My father turned to me. We never wanted to hurt you, he said. I know, I replied. And I meant it. Harm doesn't always come from cruelty. Sometimes it comes from control dressed as protection. You should have talked to us, my mother added softly. I tried, I said. You reassured me instead of answering. That was the closest we came to confrontation. No accusations, no emotional unraveling, just an acknowledgement of a mismatch. They had seen my quiet as fragility. I had seen their control as overreach. Both perceptions collided under legal scrutiny. My father nodded once, slowly. We thought we were preserving stability, he said. At the cost of my autonomy, I answered calmly. There was no denial this time, just silence. But it wasn't the same silence as before. Before, it had been an assumption. Now it was understood. I didn't threaten further action. I didn't mention referrals or investigations. Those processes would unfold independently. I simply held my leather folder under my arm and prepared to leave. As I walked toward the exit, my mother said my name again. Ethan. I turned. We underestimated you, she said. There was no defensiveness in her voice now, just recognition. And that was the only thing I had wanted from the beginning. Not an apology, not punishment. Accuracy. Confrontation doesn't require heat to be decisive. Sometimes it requires nothing more than evidence, and the willingness to stand still while truth corrects the room. I stayed in Seattle for 2 more weeks after the hearing, not to celebrate, not to argue, to recalibrate. Control of the trust assets was transferred back to me formally through updated filings. Account access was restored. Signatory authority was corrected. Digital permissions reset. My attorney walked me through every structural change with the same calm precision she had maintained from the beginning. There's something sobering about seeing your own autonomy reinstated on paper. It doesn't feel triumphant. It feels right. I met my parents once during that time, at a quiet cafe near the waterfront. Public, neutral, uncharged. We didn't rehash the legal arguments. We didn't dissect the forensic report. There was no value in reopening details already resolved. Instead, we talked about practical matters. How the properties would be managed going forward. What boundaries would look like. What transparency is required. I made one thing clear. Not aggressively, not emotionally. I don't need protection, I said. I need accuracy. My father nodded. I see that now. It wasn't a dramatic reconciliation. There were no tears, no cinematic apologies. Just a shift in dynamic. For most of my life, I had allowed myself to be the stabilizer, the quiet mediator who absorbed tension to maintain peace. That version of me wasn't wrong, but it was incomplete. What changed wasn't my temperament. It was my boundary. I still don't raise my voice. I still don't react impulsively. I still believe calm is stronger than noise. But now my calm includes enforcement. I no longer interpret concern without evidence as care. I no longer accept vague reassurance in place of documentation. And I no longer assume that silence will protect me if structure is misused. When I flew back overseas, the city skyline looked the same as it always had. My work continued. My routines resumed. But internally, something fundamental had settled. I am not the vulnerable narrative someone else can write. I am not the quiet son who will allow identity to be filed without review. I am not passive simply because I am restrained. What I learned through all of this is that quiet dominance isn't about overpowering anyone. It's about standing firmly enough in documented truth that you don't need to. There's no bitterness in me. Disappointment? Yes. Clarity? Definitely. But bitterness would mean I'm still reacting. I'm not reacting anymore. I'm defining. My grandfather once told me, control is rarely loud. It's maintained in the margins, where the details live. Now I understand exactly what he meant. I live in the margins. I read the footnotes, and I sign nothing I haven't verified. If there's one thing this experience taught me, it's this. Silence is not weakness, but silence without structure can be rewritten. For months, I was described, subtly, politely, lovingly, as overwhelmed, vulnerable, in need of consolidation. And because I didn't shout, because I didn't react emotionally, that version of me began to solidify in rooms I wasn't physically present in. That's how identity gets reshaped. Not through dramatic accusations, through paperwork, through tone, through concern that goes unchallenged. What changed everything wasn't anger, it was documentation. I didn't win because I argued better. I didn't win because I exposed someone publicly. I corrected the record because I verified it. There's a difference. Quiet dominance isn't about humiliating the people who underestimated you. It's about understanding that restraint, when paired with evidence, becomes unshakable. My parents and I still speak, carefully, more honestly. There are boundaries now that didn't exist before. Not walls. Just lines drawn clearly enough that they don't need to be defended loudly. And maybe that's the real outcome. Not punishment, not revenge, accuracy. If you've ever been underestimated because you're calm, if you've ever been labeled fragile because you don't perform your strength theatrically, if you've ever realized that someone mistook your patience for incapacity, then you already understand something important. You don't need to become louder to become undeniable. You need structure. You need clarity. You need proof. So I'll leave you with this. When someone defines you in a way that doesn't align with who you are, do you argue with the narrative? Or do you correct the record? I'd really like to know how you would have handled it.